friends, hope you all are doing well. I am Dr. Gurmanpreet Kaur, Associate Professor of Law at Rajiv Gandhi National University of Law, Punjab. Today we will discuss the topic maintenance under Hindu law. Firstly, we will discuss the dictionary meaning of the term maintenance. It means to support or provide sustenance. Further, a person is entitled to basic necessities of life like food, shelter, clothing, and other necessary requirements to live a dignified life. The maintenance generally covers the expenses for necessaries or essentials for the substance of life. However, it is not merely a right for survival of the claimant. Court takes into account certain considerations for fixing the amount of maintenance. Dear friends, the provisions of Maintenance Act are intended to provide social purpose. The court is to look into the possession of the property of both the husband and wife, ability of the husband to earn, conduct of the parties, and other circumstances to decide the amount of maintenance. Before fixing the amount of maintenance, the status of the parties and standard of their life enjoyed by them during the subsistence of marriage will have to be taken into consideration. Viewers, the provisions for maintenance under Hindu law are contained under Criminal Procedure Code 1973 under sections 125 to 128, under Hindu Marriage Act 1955, under the Hindu Adoption and Maintenance Act 1956, under the Protection of Women from Domestic Violence Act 2005 under section 20, where monetary relief is granted to the aggrieved wife. Moving further, let's start with understanding the objective of maintenance. Object of provisions relating to maintenance is to compel a man to perform the moral obligations which he owes to the society in respect of his wife. These provisions seek to ensure that the neglected wife and children are not left in a destitute manner on the mercy of the society and thereby driven to a life of homelessness, immorality, and crime for their subsistence. The inability of the wife and children to maintain themselves could lead to social problems, and therefore it became the concern of the state not to allow such inability to grow into social problems of great magnitude unless the consequences of such inability were checked by providing appropriate measures. Large-scale vagrancy could be the probable offshoot therefrom. Now let's study about the right to file for maintenance. The right to maintenance is circumscribed by certain factors such as the relationship of husband and wife should be proved, she must be unable to maintain herself, the husband must be having sufficient means, it should be proved that the husband has neglected or has refused to maintain his wife. Right of maintenance has a wide ambit, as a wife who has been divorced is entitled to claim maintenance from her husband, provided that she has not remarried. Whether such a wife has been divorced by her husband or she has obtained divorce or the marriage was by divorce by mutual consent, she would still be entitled to claim maintenance under the Maintenance Act. Now let's proceed further with studying in detail about the maintenance under Hindu law. The relief of maintenance is considered an ancillary relief and is available only upon filing for the main relief like divorce, restitution of conjugal rights, or judicial separation. Further, under matrimonial laws, if the husband is ready to cohabit with wife, generally the wife's claim is defeated. However, the right of a married woman to reside separately and claim maintenance even if she is not seeking divorce or any other matrimonial relief has been recognized in Hindu law alone. A Hindu wife is entitled to reside separately from her husband without forfeiting her right of maintenance under the Hindu Adoption and Maintenance Act of 1956. The Act envisages certain situations in which it may become impossible for a wife to continue to reside and cohabit with the husband, but she may not want to break the matrimonial tie for various reasons, ranging from growing children or to social stigma. Now further we'll discuss about types of maintenance under the Hindu laws. Under the Hindu maintenance laws, under Hindu Marriage Act of 1955, there are two types of maintenance which the wife can claim. First is the interim maintenance, and secondly, it's permanent maintenance. Let's first discuss about interim maintenance, also known as maintenance pendent light. Under Section 24 of the Hindu Marriage Act 1955, either the wife or the husband can claim interim maintenance. The basis of claim for interim maintenance is that the claimant has no independent income of his or her own to support himself or herself. The provision is silent on the quantum of maintenance, and it is upon the discretion of the court to determine the quantum. Similarly, maintenance pendent light is to be provided to the claimant who does not have an independent income, and the financial need of litigation expenses has to be provided by the other spouse. The interim maintenance is payable from the date of the presentation of the petition till the date of disposal of the suit or passing of the decree. Interim maintenance is supposed to meet the immediate needs of the petitioner, and maintenance pendent light is for providing the litigation expenses of the claimant. Maintenance pendent light is paid to the wife so that she can pay for the legal expenses incurred by her. Interim maintenance is awarded by the court if the wife has absolutely no source of income to maintain herself. There are no laws that lay down the amount of this type of maintenance, and it is completely upon the discretion of the court to determine how much maintenance is sufficient for the wife to sustain during the proceeding. Now let's study about the payment of interim maintenance. While framing the guidelines, the Honorable Court found that despite the statutory provisions, inter alia, requiring that proceedings for interim maintenance be disposed of in a time-bound manner, it was observed that delays defeated the very objective of the legislation. Further, the quantum of interim maintenance was being considered and decided by the courts on the basis of pleadings and rough estimations made therein. Additionally, parties would submit insufficient material, disclose the incorrect or ambiguous details, and suppress vital information. These factors made it difficult for the courts to make an objective assessment for grant of interim maintenance. Accordingly, the court inter alia laid down following directions for maintenance. Endeavor must be made for settling the dispute. Only when the proceedings for settlement are unsuccessful should the court proceed the matter on merits. Secondly, a professional marriage counselor must be made available in every court. Further, both parties have to mandatory file an affidavit of disclosure in all maintenance proceedings, including pending proceedings before the concerned court. Moving further, the respondent must submit the reply along with the affidavit of disclosure within a maximum period of 4 weeks. The court ought not to grant the respondent more than 2 opportunities for submission of his or her affidavit of disclosure. Further, on the basis of pleadings filed by both the parties and affidavits of disclosure, the court should make an objective assessment of the approximate amount to be awarded towards maintenance in the interim stage itself. Next, if during the course of proceeding there is a change in the financial status of any party, or there is a change of any relevant circumstance, or if some new information comes to the light, the party may submit an amended supplementary affidavit, which would be considered by the court at the time of final determination. Next, the concerned court must make an endeavor to decide the interim application for interim maintenance by a reasoned order. within a period of maximum 4 to 6 months after the affidavit of disclosure have been filed before the court. These directions may be modified by the concerned court if exigencies of a case require the same. It would be left to the judicial discretion of the concerned court to issue necessary directions in this regard. Dear friends, now we will discuss about permanent maintenance. Permanent maintenance is paid by the husband to his wife in case of divorce, and the amount is determined through a maintenance petition. Section 25 of the Hindu Marriage Act 1955 states that the court can order the husband to pay maintenance to his wife in the form of lump sum, or it may be a monthly amount for her lifetime. However, the wife may not be eligible for maintenance if there are any changes in her circumstances. Moving further, now we will learn about maintenance of wife under Hindu Adoption and Maintenance Act 1956. Section 3, Clause B, Subclause 1 of the Hindu Adoption and Maintenance Act 1956 defines maintenance as provision for food, clothing, residence, education, and medical attendance and treatment. In case of an unmarried daughter, it also includes her marriage expenses. The provisions for permanent maintenance are also present in all the personal laws and are substantially similar. Further, let's discuss the grounds for award of maintenance. Upon proving that at least one of the grounds mentioned under the Hindu Adoption and Maintenance Act exists in the favor of wife, maintenance is granted and she is entitled to live separately from her husband without forfeiting her claim to maintenance under Section 18, Clause 2. These grounds are as follows. Firstly, if the husband has deserted her or has willfully neglected her. Secondly, if the husband has treated her with cruelty. Next is if the husband is suffering from virulent form of leprosy or any venereal disease or any other infectious disease. Next is if the husband has any other wife living. Next is if the husband keeps the concubine in the same house as the wife resides or he habitually resides with the concubine elsewhere. Further, if the husband has ceased to be a Hindu by conversion to any other religion, or any other cause which is justifying her living separately. In the case of Meera Naresh Walia versus Sukumar Naresh Walia, AIR 1994, Madras 168, the wife had been living alone and all children had been brought up by her without any assistance and help from the husband. And there was a clear case of desertion. The wife was entitled to separate residence and maintenance. The thoughtless action of the husband of evicting the wife from the house where she had been living in collusion with the purchasers of the house and the police inflicted a deep wound on her amounted to cruelty. The wife was entitled to live separately and claim maintenance. Merely because the wife fails to strictly prove the specific grounds urged by her, she cannot be denied the relief. Moving on, let's proceed further with studying the concept of quantum of maintenance. While settling out the criteria for determining the quantum of maintenance, there can be no straitjacket formula for fixing such a quantum. Stressing upon the importance of maintaining a careful and just balance between all relevant factors, it is important that the maintenance amount awarded must be reasonable and realistic. It should be taken into account that maintenance awarded to the applicant should neither be so extravagant that it becomes oppressive and unbearable for the respondent, nor it should be so meager that it drives the applicant to penury. The means and capacity of a person against whom the award has to be made should be taken into consideration for determining the quantum of maintenance. In fact, in the case of the husband, it is not only the actual earning but also his potential earning capacity which must be considered. That is, there is a presumption that every able-bodied person has a capacity to earn and maintain his wife. The income of the husband is a significant factor to be considered by the court in fixing the quantum of maintenance. It is disposable income and not the gross income which is to be considered. Section 23, Clause 2 of the Hindu Adoption and Maintenance Act 1956 states the factors to be considered in determining the amount of maintenance payable to the wife and children, and they are as follows: the position of and status of the parties, the reasonable wants of the claimant, the claimant if living separately is justified or not, the income of the claimant, the value of the claimant's property, and the number of persons entitled to maintenance under the Act. Even if one of these grounds exists in the favor of the wife, she will not be entitled to relief if she has indulged in any adulterous relationship or has converted herself into any other religion, thereby ceasing to be a Hindu. It is also important to note here that in order to be entitled for the relief, the marriage must be a valid marriage. In other words, if the marriage is illegal, then the matrimonial relationship between the husband and wife is non-existent, and therefore no right of maintenance accrues to the wife. Further, let's discuss about the date from which maintenance is to be awarded. The maintenance in all the cases, including Section 125 of the Criminal Procedure Code, is to be awarded from the date on which the application was made before the concerned court. This was done with the view to prevent the dependent spouse from being reduced to a destitution. Let's now discuss about the execution and the enforcement orders of maintenance. The court observed that the execution petitions following an order granting a maintenance usually remained pending for a long period of time. It recognized that if maintenance was not paid in a timely manner, it would defeat the very objective of the social welfare legislation. It was further held that the order of maintenance may be enforced as a money decree of a civil court as provided by various provisions of Civil Procedure Code, including provisions for civil detention, attachment of property, etc., more particularly provided in the relevant provisions therein. Now, let's discuss some instances where maintenance is not granted under certain circumstances. First is where the second wife is not entitled for maintenance. In the case of Chandaram Bankar versus Srimati Rama Devi, AIR 2010, Rajasthan 176, the inherent powers are to be exercised by court only in the absence of statutory provisions and not to circumvent a statutory provision. Grant of maintenance to the second wife in exercise of inherent powers, though she was not entitled to maintenance under provisions of Hindu Marriage Act 1955 and Hindu Adoption and Maintenance Act 1956, are not permissible. Further about quantum of maintenance. In Shobha Suresh Jumani versus Appellate Tribunal, Forfeited Property and Another, AIR 2001, Supreme Court 2288, the maintenance may be awarded up to the extent of rupees 1/5 income of the spouse. So in this case, husband was drawing a salary of about rupees 35,000 per month, and an amount of rupees 3,000 per month had been awarded by way of maintenance for life. After retirement, the husband was drawing a provisional pension of rupees 15,115 rupees per month. Order of the family court maintaining the amount of maintenance of rupees 3,000 as maintenance to wife even after retirement of the husband is not proper. It has to be readjusted. Moving on, further we'll discuss that if wife is living separately, whether she is entitled to claim maintenance. In the case of P. Srinivas Rao versus P. Indra, AIR 2002, AP 130, Section 18 of the Hindu Adoption and Maintenance Act 1956 only provides that a Hindu wife shall be entitled to maintained by her husband during her lifetime, and if she is living separately, as provided under subsection 2, she is entitled to claim maintenance from her husband. Further, whether a deserted wife would be entitled to maintenance or not, in decided case of Dayali Sukhlal Sahu versus Shrimati Anju Bai Santosh Sahu, AIR 2010 Chhattisgarh 80, the provisions of section 18 and 20 of the Hindu Adoption and Maintenance Act 1956 cannot be interpreted in such a manner so as to defeat justice to the deserted wife and her dependent child. Even otherwise, food, clothing, residence are essential requirements for human survival. Providing such essential requirements to the wife and children, being the statutory and moral duty of the husband, the same cannot be denied or postponed. Next, we'll discuss the obligation of father-in-law to maintain his daughter-in-law. Under Section 19 of the Hindu Marriage and Adoption Act 1956, one of the conditions for father-in-law to maintain the daughter-in-law is that the daughter-in-law is not able to maintain herself from the estate of her parents. A clear finding is necessary whether her parents have estate sufficient to maintain her and at what circumstances she is unable to maintain herself or by her parents. So for this purpose, the parents of the daughter-in-law are required to be heard. This is only possible if they are made parties to the suit. In the absence, any finding will not bind them. Where from the estate of the parents the daughter-in-law can maintain herself, the question of obligation of father-in-law does not arise. It is also to be found out whether there is any co-parcenary property in the hands of the father-in-law from which the daughter-in-law is deprived of her share. So maintenance is not granted under the following situation. So let's discuss those situations one by one. The wife is not entitled to claim maintenance if the following circumstances exist. Firstly, if she has ceased to be a Hindu by converting to another religion. Secondly, if she is guilty of adultery, that is, she is unchaste or has indulged in physical relations with another man, or if she has remarried after the divorce. So in conclusion, we'll discuss by virtue of judicial pronouncements and other steps, various rights have been given to the woman. They will be fruitful only when women educate themselves and their families and empower themselves economically and socially for their well-being. Through awareness and education, they can understand their rights and worth, and thereafter the social upliftment of the whole community is possible. It is a historical fact that no society has ever lived in peace until their women folk are at peace. Although maintenance is a right of the wife, still many women are being denied to claim their rights of maintenance. Proper implementation is necessary to abide by the law of the land and ultimately to make it a grand success. So with this, we come to the end of the lecture. Thank you.